Doesn't happen often, but it happens more often than you would think. Anyone could be accused of sexual assault, and it's happened to my clients before. Here's an example. Stepfather, been married to mother, maybe a little bit of time, maybe a lot of time. Maybe he's the only father that her daughter has ever known, but the daughter starts to come into her preteen or teenage years, and she gets the idea somehow that she could manipulate the family into getting her way. Maybe she's in trouble because of her grades and it gets her parents off her back. Maybe it gets her to be able to spend more time with her boyfriend and sleep over at his house. Whatever her goals are, she finds that by accusing her stepfather, who maybe is the disciplinarian or the stringent person in the household, by accusing him of sexually assaulting her, she can get him moved out of the house and put him on the defense, essentially neutralizing him and giving her full reign of the house. What do you do if this happened to you? Well, the first thing that I do is hopefully you hire a lawyer in the investigative phase so that the lawyer can reach out to the investigators and try and keep the charges from ever being filed. The truth is, pretty much every time that a child reports sexual abuse, first thing that's going to happen is that CPS kind of authorities are going to get involved. In Texas, it's the Texas Department of Family and Protective Services, or DFPS. After that, probably the investigator is going to report this case to the prosecutor, who is going to make a decision whether to charge or not to the person with sexual assault of a child. Almost every time, the charges are going to get filed. So the next thing that a good defense lawyer is going to do is they're going to ask the prosecutor about filing something called a grand jury packet. What's a grand jury? It's, in most cases, 12 strangers who meet in a secret room and they hear a summary of the evidence in the case. And they decide whether probable cause exists to charge a person with a crime or to not charge them with the crime. Prosecutor, defense lawyers, clients are not allowed in the room. It's just the prosecutor, the grand jurors, and the bailiff who has those people in charge. So how do we advocate with the grand jury? A grand jury packet, a written document where we include certain things to try and help the grand jury understand that you didn't do it. The number one thing we usually lead with when my client says, Phil, I didn't do it, is I send you to go to a polygraph examiner, a reputable polygraph examiner who's testified on behalf of the state and the defense over decades and decades of time. Now, polygraph examinations are not admissible in court, so the only chance we're going to be able to have to use the polygraph to our benefit is with the prosecutor trying to convince them not to file the charges, or with an investigator trying to convince them not to file the charges, with the prosecutor to try and influence their decision, and with a grand jury. If you pass a polygraph, that's front and center usually in a grand jury packet for me, followed usually by an explanation of who my client is. Say they served in the military and were honorably discharged. Maybe they serve in a position of trust in the community. That's sometimes a double-edged sword, because we think as a community that if you have a position of trust, like a pastor or a police officer or a school teacher, and you're accused of this kind of thing, is that much worse. But we want to cast you in a light that the grand jury is already thinking, this doesn't seem to fit the profile of the kind of person that would be a pedophile. Then after that, you start to dig into the context. What are some of the things that suggest that this is a lie? For example, there are often text messages, photos, videos of the defendant and the complainant from before the date of the alleged offense and after the date of the alleged offense, where there's no change in the relationship. They're happy, they're going to the zoo, they're going to theme parks, they're out to dinner, they're celebrating birthdays, smiling, hugging, normal parent-child stuff. We want the grand jury to see that usually the relationship is normal, and this is just a lie that was custom made for a purpose. And then we have to answer the question, and we can't always answer it perfectly because we can't climb into the accuser's head, but we want to answer the question for the grand jury: why would they make this up? So we try to answer that as best we can. Usually it's some kind of manipulation. There's something that the accuser is trying to accomplish. And finally, we want to include letters from people who know the accuser, whether it's a parent, a grandparent, an uncle, an aunt, a school teacher, school counselor, people who have an opinion about this person's character for honesty or dishonesty. Oftentimes, even close relatives will say, this person manipulates, they lie, and this is exactly the kind of lie that they tell to try and accomplish their goals. When we put all that into a packet, I've had pretty good success in having grand jury issue what are called no bills, which is when the grand jury finds that there's no probable cause to believe that the case happened, and basically the case gets dismissed. If you want to know more about criminal defense in general, or specifically about these kinds of cases, hit the subscribe button and make sure to hit the notification bell so you don't miss the next video. We'll see you in the next one.